of jurisdiction. The accused must be properly identified in such a fashion there is no room for mistaken identity. The statute of offense must be identified by its proper or common name. A number is insufficient. If a number were to be deemed sufficient, government could bring new and different charges at any time by alleging clerical error. For any act to be triable as an offense, it must be declared to be a crime. The acts of the alleged offense must be described in non-prejudicial language and detail so as to enable a person of average intelligence to understand the nature of the charge. The charge must not be described by parodying statute, not by the language of the same. The naming of the acts of the offense describes a specific offense, whereas the verbiage of a statute describes only a general class of offense. Facts must be stated. Conclusions cannot be considered in the determination of probable cause. The accuser must be named. He or she may be an officer or a third party, but some positively identifiable person, human being, not an agency, must accuse. Some certain person must take responsibility for the making of the accusation, not an agency or an institution. This is the only valid means by which a citizen may begin to face his accuser. Also, the injured party must make the accusation. Hearsay evidence may not be provided. Anyone else testifying that they heard that another party was injured does not qualify as direct evidence. The accusation must be made under penalty of perjury. If perjury cannot reach the accuser, there is no accusation. Otherwise, anyone may accuse another falsely without risk. To comply with the 5 elements above, for the accusation to be valid, the accused must be afforded due process. Accuser must have complied with the law, procedure, and form of bringing in the charge. This includes court-determined probable cause, summons, and notice procedure. If lawful process may be abrogated in placing a citizen in jeopardy, then any means may be utilized to deprive a man of his freedom. And all